This conference will now be recorded.
And for whatever reason, I'm still not able to share my screen. But do you think maybe it might be a workaround if I just send the PowerPoint to you and we can just kind of broadcast it that way, by any chance?
Well, yeah, I mean, you should be able to share the screen at the bottom where it
I
says
agree.
share screen.
I see it, but unfortunately, it's just it's unclickable. But I see the icon where I should be able to click it.
Okay, yeah, because when I made you the presenter, you should be able to do all that. But yeah, if you send me the PowerPoint, I'd be happy.
But let's, just because I don't want to waste anybody's time, we'll just kind of do this.
Sure.
This workaround.
So send me the PowerPoint, and as soon as I get it, I'll put it up on my screen.
Or yeah. Here we go. Here, I'll just I'll reply all to that email that you sent out.
Okay.
Yep. Okay, so that should be coming in pretty soon here. Maybe I'll give it, just a little bit of time so we can get that out there.
Yeah, if it's a big file, it might take a little time.
For you guys, right? I mean, this has been, I guess the problem is there's not enough inventory. Is that still right?
Absolutely. We have like last month, 2 weeks supply, 2 weeks.
Oh my God.
Yeah, there was a couple of times I looked for December figures, and it was like 9 days, and then some more things happened. Yeah, but it's insane how little inventory we have.
What explains that? And I think that email just got through too.
Yeah, the thing that explains it is the fact that we have so much demand here locally, and
Yeah.
Even though builders are building, and we've got a number of people who are trying to, builders are who are jumping onto things like, yeah.
But they're just not. Okay, so I think everyone, I think you should have received that email with the PowerPoint in PDF format. So
I'm going to put it on my desk.
On the screen here.
I'm putting it on my desktop, and then I will share it. Yeah, I'll share it with everybody.
Oh, maybe you can just take back the controls and I can talk, and that way people can see your screen.
And you just have to tell me when. Just tell me when to advance forward. So let me open.
Sounds good. And of course, it goes without saying, if anyone has any questions through this, please ask. The opposite of what I want to do is just kind of be the droning lawyer, because I know a lot of this stuff, it can be perfect if you're having a problem with sleeping. So if you have any questions or you find an interesting comment or anything like that, of course, that would, I'm sure everyone would benefit from that.
Okay.
Okay. So here we go. With that,
can everyone see my screen? Can everyone see the screen now?
I can see it.
Yes. Perfect. Yeah. Okay, awesome, guys. Okay, so in the meantime, let me get started, since I'm sorry for all this technical stuff getting started on this. Basically, Kelly reached out to me. He is a land use attorney. He knows everything connected to dirt, is what he told me. And he is opening an office here in Bend. He has an office already in Portland, and he just reached out to kind of introduce himself. And so I asked him if he'd be willing to give a talk to us regarding what we're seeing here. And he volunteered, and I'm just so excited. And he has his PowerPoint on what we're dealing with landlords, with the eviction moratorium. And so, Terry, Kelly, okay, please.
Great. No. Well, usually I get Tony, so I'm Terry's a little. Yeah, thank you so much. And exactly, I think what we're going to talk about here is the Landlord Fund, evictions, moratoriums. But if anyone has any questions after this, I'm more than happy to talk with you, obviously for free. Answer any questions or anything related to this or anything else. Of course, we open up an office in Bend, so a lot of what I'm doing is business development, which of course involves a lot of coffees and drinks and things like that. So I'm more than happy to meet with you, and if you want to get some free legal advice, happy to provide it as well. Okay, so then with that, we'll go to the next slide here, I guess. And thanks, by the way, for kind of being the slide clicker. Thanks,
I can do it.
Yeah. So my name is Kelly McCann. I'm a real estate and construction attorney at Burnside Law Group. You can see me with my fiance there. My practice is about 60% contracts, so drafting purchase and sale agreements, all that kind of stuff. Usually for commercial real estate, just because, as you guys know, a lot of the residential stuff is form based. And then I do a lot of litigation too. So a lot of litigation on behalf of brokers that have been accused of non-disclosure, and then I don't really take sides, and that sometimes I'll do the opposite side as well. But it kind of gives me an interesting perspective on how brokers tend to get into trouble and how they can stay out of trouble too. Of course, if you have any questions in this, please interrupt. Obviously the goal is to make it useful for you all. So if you have any questions or comments or an interesting story to tell, I think everyone would benefit from that. Okay, next slide, please.
Yep.
Okay, so today's goal is we're going to try to become experts in the Landlord Compensation Fund. And, as you guys can imagine, this fund, it just passed in late December. It's still, the kinks are still being worked out. Not everything's totally clear, but by the end of this, I think you'll be as much of an expert as anyone who does not work for the Oregon Community and Housing Agency, in that we're going to know a lot about that fund. And so if anybody asks you any questions, you'll know the answers probably. Then we're going to talk about COVID evictions, what's happening there. Obviously, there's been a whole bunch of governor, executive orders passed, and what's going on there. And then we're going to talk about some of these really large earnest money deposits that apparently you guys are seeing, where builders are acquiring something like $300,000 in non-refundable earnest money. And is that even legal? Can you even do that? And if a buyer does pay that, are they able to get that back? And how non-refundable really is this? And so we're going to get into that issue too. Okay, so we'll go to the next slide. Okay, so the first things first, I guess, the Landlord Compensation Fund. So basically the big overview is this. As you guys know, there had been allocated money through Oregon State and through the federal government for tenants to pay their rent. But what was happening is a lot of tenants, for whatever reason, they weren't applying through these community associations. And so landlords, what they wanted to do is they want to say, well, look, give us some money and we'll apply on your behalf. And the Oregon legislature said, okay, we'll do that. They allocate $150 million to this fund. And then so basically how it works is the tenants have to fill out basically an affidavit. It's called a declaration of financial hardship. And it says that they've experienced financial hardship because of the COVID-19 pandemic. And then and because of that, they're having some difficulty paying their rent. If they do that, then they get added protections where they can't be evicted and they don't have to pay their rent on time. And I should say they can't be evicted for non-payment of rent. They can still be evicted for other reasons. And then they give that to the landlord, and the landlord completes an application on the Oregon Housing and Community Services website. They file the application in, and then the agency reviews the application, and then hopefully accepts the application, and the landlord is paid. As part of that, the landlord only gets 80% of the money that they were owed. So the other 20%, the landlord has to just kind of chalk up to uncollectible, and that's kind of a deal that the Oregon legislature kind of made with landlords, and that if you want something, you got to do this. I was talking with a bunch of property managers, which you guys probably know this as well, but they said generally as a rule of thumb, once someone owes more or $6,000 or more, you're just not going to collect barely anything. So it's not that you're going to collect $6,000. You're not really going to collect much. So probably most landlords, once they get to that level, they're going to say, well, 80% is a hell of a lot better than nothing. So we'll just take the 80%. And we're going to get into some more of that detail here a little bit too. So next slide, please. Okay, so the logistics of it. So this is kind of what we were talking about earlier. Just how does that money work? I think one really important thing is to determine is that which landlords get this money. And the Oregon legislature decided that they were going to prioritize landlords that, one, they are smaller landlords, so they don't own they're not a big REIT that owns, thousands of apartments. So the less units you own, the higher the likelihood that you're going to receive the funding. And so this is kind of designed to help smaller landlords out, and those landlords and the landlords that have not been getting paid. So I think it's something to the extent of if you can pay 50% or less from your tenants, then you have higher priority, and it's basically a point-based system. And so those that are very small, so someone who owns maybe one house, they rent a house, or they rent 2 houses, something of that nature, and then imagine in this hypothetical world they haven't been getting any payment from their 2 tenants, then they would be extremely high priority on receiving funds. So if they applied, they would most likely get the funds. The idea being is there's only a limited amount of money there, and so who's going to get it? So we'll kind of go. We'll talk about that a little bit too. Okay, next, please. Okay, so we kind of went into a bunch of different stuff here, and then we're going to go kind of through a storm of frequently asked questions, just kind of getting into the heart of the matter here. But before we get into that, does anyone have any questions on just kind of the basic premises of the landlord compensation fund? And I'll give you guys maybe 20 seconds or so here to ask any questions you have, or comments or criticisms.
If you guys have a question, just go ahead. Yeah, if you have a question, just go ahead and unmute your mic, or else put it in the chat. I'm monitoring the chat. Kelly, I do have a question. I saw on the last slide, it's talked about that landlords can go back and try to collect from last year's non-payment.
Right, if they don't get the money, so if the landlords do not get the funding, they can still try to collect. Basically what the idea is that if the landlord accepts money from the state of Oregon, then they're relieving the tenant of their obligation to pay. And we'll kind of get into a little bit more of that stuff too. Generally speaking though, the portal hasn't opened yet, so no landlords are getting paid yet. But how it will work is the landlords will apply in February. So obviously it's February, but maybe in a couple days from now, early February, they stated. And then what will happen is they will get assuming they meet all the qualifications and all those things are met, they're a smaller landlord, they've got a lot of tenants that are not paying, etc. Then they'll get compensated for the entire period that there was basically an eviction moratorium, right? So I think it's April 2020 is when it first started, and so they're going to get compensated for all of that rent. And obviously, it also has to deal with whether or not they're a current tenant. So if the tenant that they're getting compensated for has to still be living in the landlord's property, if they live there until December 31st, then the landlord can't collect out of this pool of money for that tenant. They have to go collect from that individual tenant, and they can't collect yet. They have to wait until March 31st to collect, because that was part of the old laws.
Okay, because I can say within our own brokerage, I know we've had several landlords who've had tenants who have not paid, who have since sold their property. And in essence, in order to do the, the 90-day notice to get the tenant out, because the person who's purchasing was going to be owner occupied, they basically had to, I can think of one case, this person lost $10,000 between failure of the tenant to be paying, and then secondly, just to get them out because they refused to go out. They were using the "you can't evict me" more, because of COVID issue, and the tenant had a landlord. So basically, it cost them a lot of money. So you're saying there's really, based upon the way this is set up, there's no compensation due back to that person who has since sold that home.
I think. This is a great question, and it's a fantastic question. From what the law is right now, which, because this is as you guys know, right, generally what happens is the legislature passes a law, and then there's a bunch of case decisions that kind of clarify the laws, and then you kind of get more certainty of what's going on. Right now, we don't have any case decisions. We just have, the statute, just the law. And so based on, that scenario right now, without the case law, yes, that it's a terrible issue for the individual who had to pay $10,000. But that's as it is right now. That doesn't mean it can't change and evolve, though. It might be, if you contact me 2 months from now, it might be a totally different story, just as, the program gets developed and case law gets developed. Okay,
great.
Yeah, assuming we don't have any more questions, I'm sure we'll have more questions once we get in here.
Okay, next
Okay.
slide.
Next slide, please. Okay, so basically what we're going to do is we're going to go through a bunch of frequently asked questions that I'm getting asked a bunch about this program, and that I think that you guys will get asked or kind of talk about a little bit too. And so this is really just kind of preemptively asking questions and seeing, kind of the answers to it. So the first question is, are landlords required to proactively provide a notice of tenant rights and a copy of the declaration form to all tenants? So do landlords have to say to all their tenants that you don't have to pay your rent, the government will pay your rent, and like that? And the answer is no, that landlords don't have to, because obviously a landlord would rather get 100% of their rent rather than 80% of their rent. And so the answer is no. The landlord only has to provide that declaration of financial hardship under certain circumstances, which are notice of termination for non-payment, service of an eviction summons when the case is based on a non-payment notice, or notice about how much rent is owed. So otherwise, landlords are kind of safe and they don't have to provide that notice, assuming the tenant doesn't know about it, which oftentimes tenants don't know about this kind of stuff. For those of you who are interested in what the declaration of financial hardship look like, there's a picture of it there. You can kind of see it's a one-page document. It basically just states that you've had a financial issue due to COVID. Basically, if the tenant signs it, that's all that needs to be done, right? There's not a huge investigation done after that. Okay, are there limits on how often the landlord can remind tenants of how much they owe, or there's a point at which it becomes harassment? So a lot of tenants are saying, well, my landlord keeps reminding me, and what they're really trying to do is they're trying to kick me out of my property or my lease. And the answer is, generally the landlord can keep reminding you, but they have to provide that declaration form. And if you have the declaration form and you do that, then the tenant is protected until the end of June from eviction. Now, if the landlord gets money from the state of Oregon, then that rent is, they don't have to pay the rent either. So that's kind of how that issue works. But regardless of whether or not the landlord receives money or not, the tenant is protected. Okay, next. Okay, are tenants responsible for late fees for rent that was due before April 1st, 2020? So April 1st, 2020 was when the first, if you guys can remember, it seems like it was, several years ago, was when the first, kind of eviction moratorium came into being. And that basically made it so that tenants don't incur late fees anymore, pursuant to law. And the answer is yes, tenants are responsible for late fees that were due before those eviction moratoriums. So next slide. Okay, can tenants be charged late fees or reported to a tenant bureau for rent that was due from April 1st, 2020 through December 31st, 2020? And the answer is no, because those are that was when there was an eviction moratorium. That was a little bit different than this one because there wasn't a landlord compensation fund. But during the old ones, the answer was no, of course, and that they couldn't be reported to a credit bureau or charged late fees during that period of time. And so they still cannot be. Okay, so next slide. Okay, can tenants be charged late fees for rent that is due after January 1st, 2021? And this is the question. So basically, if a tenant does not have any financial hardship and they do not sign that declaration of financial hardship form, generally they can be charged late fees and the landlord can charge them late fees. If they do, which of course, most tenants are finding some reason that they have a financial hardship, then they cannot be. And so that's something too important to the end of June 2021. Okay, next slide. If tenants accrue late fees from now until they turn in their declaration, do they have to pay those back, or are they forgiven because they declared that they have a financial hardship? So this is kind of a really big question, but basically it's so House Bill 4401 is the bill that all of this this new landlord compensation fund and everything with that was included in. And it states that a landlord may not assess a late fee during the emergency period or before the end of the grace period, and the emergency period is extended to June 30th if the tenant submits a declaration. So therefore, as long as basically the real thing to remember here is if the tenant submits the declaration, basically it's just an extended eviction moratorium, and so there's no late fees that can be held there. But if they don't do it, then they can. Okay, so then we've got basically I incorporated a couple different breathers in here, but if you guys don't have any questions after that, we'll kind of keep going through some of the questions. Of course, I understand that a lot of this stuff is it can be kind of repetitive in the questions, but for sure you're going to be asked this stuff. So I imagine it's probably important stuff to know. Any questions? Otherwise, we'll go to the next one, I guess. And of course, if you have any questions during it, feel free to interrupt as well.
Yeah, I'm still monitoring the chat. So far, nothing.
Okay, sounds good. Yeah, I think it's, I'm just asking you a bunch of questions and answering them. So,
Okay.
so that should, yeah, hopefully this answers any questions you guys have. Okay, so we'll do the next slide. Okay, when is back rent due? So all tenants have until March 31st, 2021 for back rent owed from April through December of 2020. There is no declaration required for this grace period. Qualifying tenants, those who have experienced financial hardship and submit a declaration, have until June 30th, 2021 to pay their back due rent. And that's if, of course, that the landlord is not compensated for that, right? Okay, so next. Okay, if a tenant experienced financial hardship last summer, but is now able to pay, do they still qualify for the moratorium? So if they're totally fine now, but they were, they had a job loss or any other financial hardship, are they covered? Yes, they can still do the declaration because they had a hardship and their and the eviction moratorium is extended. Okay, so next slide. Okay, for rent that was not paid from April 2020 through December 2022, excuse me, 2020, no financial hardship form turned in. Can landlords issue a non-payment termination notice on April 1st, 2021? And April 1st, right, is basically, so the answer to this question, and the importance of April 1st is that's the end of March 31st is when the payments all start to become due under that date. Because otherwise, under the old eviction moratoriums, tenants had basically they couldn't be evicted until the end of December, but then they had an additional 3 months in which to pay back their back due rent. And the answer to this is yes. So that if the tenant does not pay and they don't pay that back due rent by that date, and they don't turn in the declaration, then they can be evicted on that date. Okay, so go to the next slide. If a person submits the hardship declaration, is there any issue with them making partial payments when they're able to? And the answer is no, that even if they submit a declaration and they say, okay, well, we'll make, half payments and then, maybe we'll ramp that up a little bit later, they can still do that, and that's completely legal. And that's, of course, a big issue, especially if the landlord's not getting compensated from the state. Okay, continue. Okay, what if a tenant is not able to get rent assistance and the landlord does not apply for landlord-based compensation and the tenant then owes way more than they can pay by the final deadline? Okay, so this is kind of a big question. And basically the issue is that if the landlord's not getting, rent assistance, and then, the tenant's not having this issue, can they make a payment plan? And yes. And the reason why people are asking about these payment plan issues is people are concerned about if I enter a payment plan and it's kind of like a new contract that we're entering into, does that affect all of our rights from now on? And that no longer is this old lease agreement that we had, our contract, now we've got this new one. But the answer to that question is that even if you have this new one, you can still apply. And then, but most tenants are probably going to get money because there's about $500 million being allocated to this, with $300 million from the federal government and about $200 million from the state. So significant money is that tenants should be eligible for. Okay. All right. Does the prohibition on reporting non-payment balance to any consumer credit agency, include stopping landlords from sending past residents to collections? So this is kind of the, this might have been a little bit of your question. Imagine if, you know, because Leanna, she talked about, you know, somebody sold their property when they had a tenant in there and they kicked out the tenant in order to live in the house, or in the unit rather. Imagine that they hadn't done that and they had merely, you know, just kept the property and then that tenant had moved out. Are they able to report them saying that they're not doing it? And the answer to that question is, if the debt is for rent owed during the moratorium period and it's either debt from before December or the tenant has submitted a hardship declaration, then the landlord may not make a report to the credit bureau and may not pursue collections while the tenant is covered by the moratorium. After the tenant has moved out, the law is less clear. So this is, you know, kind of going to the same issue that a lot of these things are still being worked out. And so we really don't know. And I think if I was a landlord and I was kind of thinking about doing this, I would proceed with caution because oftentimes, you know, tenants can get attorney fees and all sorts of penalties against landlords if it turns out that they're not, the landlord's not doing what was right or legal. And so the risk is definitely on the landlord. Okay,
Now,
so
Kelly, what if there's been no hardship declaration produced
right.
by the tenant?
So
what if that's not been done? Yeah.
If you have any tenants that, so I guess number one, if you guys have any customers that are tenants, I would advise them to look really hard and see if they've experienced any financial hardship because of COVID. And they should definitely sign that if they have. Of course, you know, you definitely want to be honest. And so if you really haven't, then you can't sign it. But so most tenants are probably going to sign that document, right? Because it gives them a lot of rights and that they don't get evicted, and they also are protected. So they're protected from eviction and they get the possibility of getting their rent paid by the state, which of course, you know, is a great thing for a tenant. And then so your question is, if they don't sign it though, can they do that? So if they do not sign that agreement because they're saying that, you know, that there's maybe they don't want to sign it for whatever reason, or they feel like they really don't have a financial hardship, then if they don't pay their rent, they can be evicted for non-payment of rent. And so again, I think it bears mentioning again, there's no eviction, a total eviction moratorium, right? Just like, you know, you spoke about earlier, where, you know, somebody was going to move into the house and they had a renter, they could kick them out. If someone's breaching another portion of the lease, for instance, they have, you know, illegal activity like a meth lab in the house, they can be evicted. Things of that nature, they can be evicted. Really, the only thing that is prohibited is just evicting someone for non-payment of rent. And so if they do not sign that declaration and they're not paying their rent, they can be evicted.
Okay.
Assuming
Good, thank
that,
you.
Yeah. Okay. Oh, I think, is this the, I think this might be the same slide. Maybe we can click it
It's the
again.
next one.
Oh, it is? Okay.
Really?
Oh, okay. It might have just taken a little bit of time here. Okay. What if a client has vacated a unit with a remaining balance of rent still due? Can they submit the declaration of hardship to prevent those charges from being submitted to collections? Also, can the tenant apply for the 80/20 forgiveness program for a former living situation? So this is kind of a tricky situation, because obviously if a tenant, you know, didn't pay their rent from, let's say, from April 1st until, you know, December 31st, are they able to, you know, just kind of, you know, submit this declaration and say, well, I was having a problem during that time, but then, you know, I used one of you guys to buy myself a nice house, you know, on the 1st of January. And so now I don't have that issue, but I'd like to submit this declaration and not have to pay that, you know, that rent I didn't pay during that, you know, I guess 3/4 of the year. And the answer is, that usually if a tenant vacates a unit with a remaining balance of rent still due, the landlord can use the deposit to pay for past due rent. If there is still remaining past due rent owed and the tenant had submitted a declaration form to the landlord before moving out, it is unclear whether the landlord can pursue collections and make the credit bureau right away, or has to wait to the end of the moratorium. So that's a, you know, again, it's just, it's unclear. And, you know, I'm sure in a couple of months we'll have some more clarity on it. Okay. Okay, and then here's a little breather for you guys in case you have any questions. I know oftentimes it's kind of hard to think of questions, just keep asking questions and answering the questions, but if you do, you know, I would love to hear them, or anything of that nature. Or if you have any concerns or anything that you're seeing with your customers or anything of that nature too.
So I'm still
All
looking
right.
at the chat. I don't see anything, so let's move on.
I'm sure. Yeah, I would have a hard time asking questions during this thing too, because it's just a bunch of questions and answers. Okay. Okay. What if a client has vacated a unit with the remaining balance of rent still due? Can they submit the declaration of hardship to prevent those charges from being submitted to collections? Also, oh, I think did we already answer this question? Or is that a different question? I can't really recall. Some of these questions start blurring together a little bit.
Oh, I actually do have a couple of questions here. One
Okay.
is, can a past tenant file a declaration after they've moved out?
Like everything, it depends. It depends on when they moved out. Do you have a situation in particular? Do you know the date?
That I don't know. It was a question from one of our brokers.
Oh,
No. It's
okay.
more hypothetical. Yeah.
Oh,
So
hypothetical? Okay.
yeah.
So the declaration issue, that only protects them if they had the declaration starting on the 1st, right? So if they made a declaration, so if they moved out on the I think it's the 31st, it's the last day of December. I think not 30th, it's the 31st, I think. If they moved out on the 31st and then they say, well, let's just get that declaration in for that rent I didn't pay during December and all the preceding months, that does not work because this law was not effective in December. But if they stayed, one more day until January 1st and they wrote that, and then they filed the declaration, then they would be protected. So it really just depends on when the law came into effect, and it came into effect on the 1st of the year.
Okay, I have a couple more questions here.
Okay, yeah.
Yeah, should would the financial declaration still apply if the lease is up in March, yet the tenant plans to stay? So I'm assuming that would be like a month to month if the lease is up in March. After that?
Yeah, and the answer is absolutely. The declaration still applies. So it's something wherein if the tenant really has, and we're going to get into those issues a little bit here in some of this barrage of questions here, but basically the tenant can submit that declaration at any time until their first court appearance at an eviction hearing. So even if they get an eviction notice and they're waiting on it forever, and then the day of their court appearance they submit it, fine. It's just they can't just totally wait until the whole process is over to submit it. But yeah, absolutely, they can do that.
Okay, and then one final question here is, the evictions of a tenant in a home being sold are 90 days from accepted contract. And that's true if the buyer is going to be moving into the property. If the landlord and tenant reach an agreement to say for 30 days, whether through let's see here, through convenient circumstances or monetary, how can the landlord keep the tenant from going against the agreement before 90 days?
So let me maybe repeat the question in my own words, just in case I'm misunderstanding the question in that way. I get the patient. But what I understand is that basically someone is buying a house or a property with the idea of we'll basically kick out the current tenants and we'll move into that property. And then they, of course, 90 days. They have 90 days to do that. And so, but then what they're saying is, well, actually, what we really want is we're going to buy it, and then we don't want to move in there right away. We want to wait a month, and during that month, of course, we'd like to have the rent. So we'll have you as a tenant there for one more month, and then we'll collect the rent. Is that correct? Is my understanding correct? And then,
yeah, I'm not quite
sure. I
sure.
can give you the answer.
Yeah, Courtney, if you want to unmute your mic and ask.
Sure. Sorry, it's slow to type on an iPad.
Oh, no worries.
Basically, what we've come up against is some homes that we're getting listings on, and the current tenant gets 90 days to find a new place to live. If they agree to say 30 days, 45 days, 60 days, whatever that is, and not the full 90, whether that's through a monetary or just they have circumstances that actually benefits the whole situation. How do you keep the tenant from coming back at, say, day 59 of 60 and saying, actually, I'm not going to move out and I want the full 90 days now, which kind of blows up all sorts of things? Like, how can you hold a tenant responsible to that agreement in some kind of capacity that would hold up?
So I think number one, it's this. If that is the situation that you're dealing with, and it sounds like obviously that's a tricky situation, but you know, that's why people like brokers, right? And that you guys make deals happen. I think what I would do is, number one, you want everything obviously in writing. Two, you have to be very careful with basically, as the law is written right now, if the tenant basically makes this financial declaration of financial hardship, they're totally protected. And so I would really advise the buyer that, look, we'll do all this stuff. We'll try to negotiate with the tenant in this way, and we'll hope it happens. But the tenant really does have this right. And so if they decide to exercise it, you know, unfortunately, we just have to go with, you know, Oregon law gives us this right. Obviously, you know, as you guys know, there's been a lot of complaints about the Oregon legislature this year from the real estate community. Obviously, landlords have reason to be concerned because they feel like their pocketbook has been kind of hurt by all this kind of stuff. But unfortunately, this might be just another example of that. So I wish I could give you a better way, just saying we'll do this, and this, and then the tenant is boxed in. But unfortunately, it just takes precedent.
Yeah, and one more question before we move on. If the landlord starts showing the home and the tenant and landlord agree to terminate the lease in 30 versus 90 days on a month-to-month, can they? I would.
It depends on the lease. So I think if you send me a copy of their lease, I'm happy to look over it. Generally speaking, the tenant has 90 days as a statutory right. Usually you can waive that 90 days because it's just a pure benefit for the tenant. But it also depends on the nature of the lease, depends on the nature of the tenancy, depends if it's, I assume it's a residential tenancy, of course, because of the 90 days. But generally they do have that statutory right there. But I think there's definitely a strong argument to be made that they waive that by saying the 30 days. But again, even if they have the 30 days and then they submit this declaration of financial hardship, which this is basically the declaration of financial hardship makes it so they can't be really evicted, but for non-payment of rent. And so that might be a tricky deal there, and that basically they're saying they're amending their lease. But send it over to me. I'm happy to look over it for free. So if you send it to me, and a lot of these questions just deal with, you know, kind of factual circumstances. So without seeing the lease, I can't really say.
Awesome. Thank you so much, Kelly. If we have no more questions right now, let's move on to the next thing. Thanks.
All right, great. Okay. Oh, next slide.
Okay.
Okay, if a tenant enters a voluntary payment plan, but is then unable to keep the terms of it, so this is kind of not really going to your exact question, that we're saying that, you know, the tenant might owe $10,000 in rent, and they're saying we're only going to pay $500 a month for a while, but then is unable to keep the terms of it. Are they still able to sign the declaration form and provide it to the landlord to be covered by House Bill 4401, which is the landlord compensation fund, is in there, protections? And the answer is yes. So that this, again, just like we were talking about earlier, the financial declaration form really supersedes everything. That's kind of the point we take.
Okay.
All right, next. Okay, if a tenant enters a voluntary payment plan, but is, oh, no. I was gonna say, that kind of seemed like the last question. If a declaration is submitted, can a landlord assume that the tenant is not experiencing financial hardship and demand, if no, and demand that rent has been paid? So basically the tenant has 10 days to give them, the landlord, this declaration of financial hardship. If the tenant has not done that, then the landlord can probably proceed with eviction for non-payment of rent. But again, a lot of these questions are really kind of academic because most tenants will find, some reason that they suffered and they'll sign that. So, okay, next question. Oh, if you click the next question.
Question? I went to the next slide.
The next slide, that's what I mean. Oh, are we at the next slide?
Yeah.
For
the family.
For whatever reason, it's not quite uploading at the same pace as when you're clicking it. But I see it now. I think it just might be taking a little bit of time. If a family is providing increased financial assistance to an individual outside of their household, so one of your kids or your cousin or something of that nature gets hurt, or really, I don't think it needs to be necessarily a direct family member like that. And do they qualify to sign the hardship declaration? And the answer is yes. And you can kind of see here the bolded list of things that constitute financial hardship: loss of household income, obviously, loss of work or wages, increased medical expenses, increased child care responsibilities, or to care with a person with disability, increased costs for child care, or other circumstances that have reduced income or increased expenses. So, I mean, a lot of people are going to fall under the reduced income or increased expenses, right? So a lot of folks are going to find that they can sign that. Okay, next. Okay, is there a deadline to submit the hardship declaration? Can a landlord give an eviction notice now if they have not received the declaration from their tenant? Okay, so this is a big question, right? In that basically, if they serve an eviction notice or say non-payment of rent or a notice of non-payment rent, they have to provide the declaration along with that, and so that way the tenant is notified of their rights under this new law. And so that, I would imagine most tenants will probably sign that, pretty willingly. For tenants who don't sign it, they can, oftentimes there's an issue that oftentimes tenants are confused. They don't really quite understand the issue here, especially oftentimes lower income tenants. There's a bunch of, nonprofit legal centers that tenants can call and kind of get walked through and feel a little more comfortable with it. Generally speaking, though, the landlord and the tenant is kind of in their interest to have the tenant sign it, because the landlord gets compensated probably, right, if they fall under the the compensation requirements, and so it's good for the landlord, it's good for the tenant if the tenant signs it. Okay, next slide.
We have a question here, and so the question is: am I understanding this correctly in summarizing the situation and saying that regardless of the agreement reached between the landlord and the tenant, if the tenant fills out the declaration, the tenant is not bound by any agreement with the landlord?
When you say any agreement, I think that might be a little too broad, right? But generally speaking, it's basically, so the agreement is for non-payment of rent, right? So you can evict someone, if we kind of take a step back, for any reason other than non-paying rent. So if, again, we're using like the meth lab example, or the, there's a law in Oregon that if you have a tenant and you want to make the space available for a member of your family, you can do that. You can kick out the tenant. So you can do that issue. There's a whole bunch of different laws out there that you can evict someone for a reason other than non-payment. But if it's just non-payment of rent, so if the tenant says like, oh, hey, I would imagine if the tenant says, oh, well, I'm waiving my rights under this law and in exchange for lower rent payments or something of that nature, that's probably void for public policy reasons. And this probably takes precedent. But again, if you send me the contract, I'm happy to look over it for free. All this stuff really just depends on the circumstances. So I can't just say it all the time. Yeah, next, please. Okay, what if a tenant has not paid on January 1st? How long does a tenant have to qualify to give the declaration to the landlord to qualify for extended protections? Okay, they should give the declaration form as soon as possible to prevent the landlord from giving notice of non-payment. If they haven't given the form, the landlord can give a termination notice for non-payment, but the notice from the landlord must include a notice of rights and a declaration form. The tenant will have 10 days to get that form back to the landlord. to stop the filing of an eviction case. The last time the tenant can submit the form is at the first court appearance. The best practice is for qualifying tenant to use the declaration form right away. So if any of you guys are tenants, you should, and you have had a financial hardship, you should file that form, regardless of whether or not you probably expect to pay your rent, because you might as well, and just in case you fall on hard times, you've already done it. So that would be kind of my advice, and if you have any tenants, that's what they should do too. Okay, next. Okay, breather. And so thanks you guys for interrupting me too with the questions. Obviously that makes it more interesting and hopefully a little more relevant too. So any questions we got right now during this little breather here?
It doesn't look like anything right now.
Okay, sounds good. We'll keep going. Okay, so I guess here's the question. Do you want to keep going through some of these questions, or do you kind of want to, because I see we only have 13 minutes left, or we can kind of go to the construction earnest money deposits? What do you think?
I think that earnest money deposits would be important, unless people tell me that we want to keep on going on with this, because this is obviously very helpful stuff. So you guys have any?
Oh, sorry, I didn't mean to interrupt.
No one said anything, so let's kind of go on to the next area. So should I just skip through these, because everyone will have a copy of this slide?
Yeah, and so if you guys want, you can. These are just kind of the questions we get asked a lot. So if we just kind of skip through this, we'll go to the construction issue.
Okay.
Those are, yeah.
That's my landlord.
Next. Oh, keep going.
COVID evictions. Okay.
If you guys have any questions, you can call me. I'll answer that. Okay, so here's the large earnest money deposit issue. Okay, so the issue that I've been hearing is that general contractors are requiring gigantic payments or earnest money deposits, which of course is the more legal term for it, in the realm of like $300,000, which is really just shows you the heat of the market in Central Oregon as a condition for accepting a job. And the big issue, of course, is the risks there are, if a buyer gives $300,000, they buy and a lot of times the contractor, I think, is using this money to buy a lot, and maybe it's for some of their operating expenses as well. What are the risks? Well, obviously, there's a huge risk that if the economy crashes during that time, there's a risk that the lot could be worth a lot less, and so there's depreciation in value there. There's a risk in that maybe you do not own the lot, the builder owns the lot, and you just own an earnest deposit money to buy the lot. There's an issue in that I mean there's this incredible amount of issues, right? In that what happens if the bank, the builder goes bankrupt during that time, or they take your money and they realize, well, they've got many people that buy this $300,000 earnest deposit, they can leave the country, or all sorts of issues, right? There's tons of issues here, and so what does an owner do to protect themselves, and how can an owner do this? And so we'll kind of go to the next slide, and we'll talk about some ways that an owner can do that and what they should do. So basically, the real issue is this. One, if this happens to you or to a client of yours, number one, it's completely legal for a builder to do this. So if they're requiring a gigantic earnest money deposit, that is completely legal. They can do it. And really, the only issue is whether or not the buyer. It's just an issue of market dynamics, right? If there's enough buyers willing to do this, and there's not enough sellers of building services, builders, then this is kind of what happens in the market, right? That builders start doing this kind of stuff. Which obviously is great for builders and not necessarily that great for buyers. But what I would recommend is that, I kind of go to the old saying, right? That you name the price. I'll let you name the price if I can name the terms, right? And that, if they're demanding this gigantic earnest money deposit, fine. Maybe I'll pay it, assuming I have $300,000 available. But we get to kind of negotiate what those terms look like. And so I think number one, what's really important to do is put that earnest money in, in a third party's hands that you trust, right? So oftentimes these are, to like title companies or banks or things of this nature, third parties that are neutral. so I think it's probably a good practice to, if you're able to, and you're not totally desperate for a house by that builder, don't just give it to the builder right out, right? And then two, I think it's really important to have the, which something like $300,000, which is enough money to merit, kind of a custom contract. Really, hire a lawyer. It might cost you $1,000, but it might save you $300,000, right? And then that way you have that contract written in the way that, if this happens, or if the builder starts getting a little shaky financial ground, or if they can't get this lot, or blah 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 happens, that we get that money back, and then so that way the buyer has a lot more rights to that earnest money. And so, in generally, in my practice, what I've found is that, because I represent usually higher net worth, residential transactions, just because those are the kind of folks that tend to bring a lawyer in. And generally speaking, on properties that are selling for maybe $2 million or more, that there tends to be, oftentimes for the buyer, I'm the only lawyer there. And then so we're able to negotiate a really favorable deal for that buyer, just because for whatever reason, contractors don't tend to hire lawyers that much. And so the terms tend to be pretty favorable for the buyer, even though the money might seem kind of, like extortion at first glance. But definitely an interesting time for sure to be around in the real estate market when you start seeing things like $300,000 earnest money deposits. All right, so next question, or next slide. Okay, Breather, does anyone have any stories to share about that, or any problems that you've run into about that kind of those earnest money deposits like that?
Yeah, I can share some stories from what I've been talking with in the brokerage. Obviously, right now, with no inventory, there's a desperation from a lot of our buyers to get homes, and there are builders out there who are willing to get into contract early and before they've even broken ground. But in this scenario that I'm sharing with you, these builders are demanding like $300,000 non-refundable released to them earnest money deposits. This is what they are demanding. And the thing is, there's no protection for our buyers because the builder technically does not even own the land yet. They are like they're at a point in which they will be utilizing this money to purchase the land and then start building the home. And so basically they're using our clients' money to purchase with no assurances that in the event our buyer for whatever reason can't perform once the house is done, say that they've lost a job or they've got to be relocated or someone's died and they can't perform, that earnest money is gone. It's $300,000, and this is a major issue. And this is happening in one particular development in particular that I can think of, in which this is the nature of every builder in this neighborhood, and it's a very desirable part of town. So my concern is our representation of our buyers in this scenario. $300,000 is a lot of money to be walking away from because it's non-refundable, and that's what the builders are demanding. So here's what can they do?
Yeah, well, number one, what they should do, anybody who's going to sign a non-refundable or about to sign a non-refundable contract for $300,000, unless it's like Jeff Bezos. I mean, that's a lot of money, right? $300,000 to have non-refundable. They should definitely seek legal counsel before they sign that, because that's just too much money to risk. And then I think the big issue that they should do too is perhaps there's a bunch of different options. Like maybe the buyer buys the lot themselves, and that way they have the lot in their own name instead of the builder's name. I mean, there's a bunch of different things that might negotiate room there that where it kind of meets the builder's needs and the buyer's needs, and they can enter into it without just giving the builder.
Yeah, and Kelly, we suggested that because in that point it becomes a custom build, and our buyer at least owns a lot, and that was suggested and refused. So,
well, I wish I had the negotiating leverage that those builders do.
Yeah.
What a it'll be interesting to see if they continue to have this much leverage in a couple of years from now, because otherwise we definitely should have all become builders.
This is the scenario that we're dealing with in this one particular area in town, and it's just so much demand for this product that's being built by these builders, and they're getting away with it. And again, my biggest concern is our protection for our buyers. And there's nothing, when the non-refundable earnest money, it's said to be non-refundable, and it doesn't matter if our buyers ultimately can't perform, because they'll argue it's non-refundable. Sorry.
Yeah, I think generally speaking, if that does happen and anybody gets, doesn't end up with the better end of the deal there's definitely arguments they can use to try to get that money back, and that they can say it's fraudulent, unjust. I was unsophisticated. You were a very sophisticated builder. You took advantage of me. That there was duress, all these kind of things. So I don't think, if that does happen to one of your customers, I wouldn't wave the white flag. I would say you can probably still, you can definitely always sue, right? But there's definitely, you might not get the whole $300,000 back, but you might get 200. So, but what a crazy situation.
Yeah, I've got several people asking where this is. This is the new phase in Northwest Crossing, guys. It's the new, and it's the area that's not yet fully platted. It's the guild builders who are purchasing these lots. And again, we've had two instances in which we've approached builders who are in reservation on these non-platted areas, and both of them, they're represented, and the contract coming back from the sellers, the builders who don't yet own the land, is that, well, you want to get in early like this, 300,000 non-refundable, release to us. So yeah, Discovery West, yeah.
Yeah, I guess that just, to me, it kind of just goes to the same thing. No deal is a must-do deal, right? And so, if you had told me that, that COVID, in the midst of this COVID pandemic, you would see things like that a year ago, I would have never believed that. So that's just shows you can never predict the future.
Well, in a seller's market, the ball is in the seller's court, and they're dictating terms, and these builders are dictating these kind of terms. The argument on the other side is the risk that they're taking, in that they're now doing a semi-custom home. But I'm just saying, is it really worth the risk of loss of that kind of funds for your client if they, for whatever reason, can't perform? I always think market do change, and things will turn sometime, but my concern still is, how can our buyers be protected?
Yeah, and it sounds like you're doing everything you can do, and it's great. I think for a broker's perspective, though, it's also important, if you do see any of those deals, make sure you send some emails saying this is a very big risk here that you're taking, because obviously. We had meetings with one set of clients and sat down with them, and we made the proposal like you had suggested, that our buyers end up being the people who purchase the lot. And again, because of the guild scenario and the way that the developer will only fund, he only wants to sell these things to the guild builders. So selling them directly to a lender, to a buyer, is one of those things that is not part of their business model in that area. And again, it's one of the most desirable areas in town. Well, it would be weird if it wasn't very desirable. And I'd really have to worry. Wow, that is incredibly interesting, though. I honestly have not heard any stories like that outside of Bend. So that's just but I think Bend, you got a lot of the Californians moving in, and you got all sorts of, kind of fun things happening here.
Yeah, Carol, one of the things and this is for the whole brokerage too, one of the scenarios geared towards this situation, I was at an OER convention about 2 years ago, maybe 3 years ago, in which there was an attorney there who was discussing non-refundable earnest money with a builder, and talked about a court case in which a similar situation was happening, in which a builder who owned the land was building this home, and a buyer came in early and wanted to make a bunch of changes. And sure enough, the builder accommodated that, and it ended up being that the buyer had put in about $100,000 worth of upgrades and changes to the property, and getting at the point in time when the home was almost ready to be sold, the buyer had a job transfer and could not perform on their purchase. And so they went back to the builder and said, I need my money back. And the builder said, sorry, non-refundable is non-refundable, you don't get it back. And the buyer at that point sued. And the lawsuit that came out of that, the judge said basically that earnest money needs to be reasonable. And the seller, in this case the builder, was able to sell this property to somebody else. And the judge said, no, you don't get to keep that money, and gave them all the money back except about $2,000, because he said earnest money has to be reasonable. This is what this judge said. So I don't know ultimately what a buyer in this situation could do locally. I think a lot depends on court cases, but there is that precedent out there that someone would have to research and use in a lawsuit.
Oh, I'm sorry, I mentioned it has to be reasonable. But the thing is that, you know, you're not going to be able to convince the builder that they have to be reasonable and still get the house.
No.
Right?
No.
But it's good to in your back pocket in that, you know, even if this thing does fall apart, I can still sue. But imagine if you sue the builder and the builder's bankrupt, right? Because
yeah, absolutely,
you know,
absolutely.
Still sue, but you know they don't have any money.
Yeah, absolutely.
What a terrible situation. Yeah. Well, I'm sorry to hear that your customers are having to, you know, put up with that. And congratulations to the builders.
Yeah, they're doing well.
Yeah. All right.
Do we have
have any questions?
More questions? Or anybody? Any other questions? Yeah, Danielle, I agree with this. In the case of one of our buyers, they did walk. They didn't want to risk this. In another case, we worked really hard and negotiated that $100,000 would be returned to our buyer in the event, because we are in contract in one case. We negotiated that $100,000 would be returned to our buyer in the event they couldn't perform. And we finally got, at least they would be out $200,000, but at least they were getting $100,000 back, and that's in the contract right now. Again, these builders / sellers are definitely dictating terms.
Well, congratulations on getting that in the contract, because it sounds like even though it's still ridiculous, $200,000. It sounds like that was a major feat. So congratulations.
Yeah.
All
Do you
right.
have more, Kelly?
Well, I think we had. Well, I mean, we can keep going a little bit longer, but I think we're at time. So I'll just, you know, we can, obviously I don't want to keep you guys, and, you know, you need to, you know, get to work and, you know, start selling things. So.
Well, thank you so much. And as Kelly said, if you have other legal questions, he's happy to respond to questions you may have directly with him. And obviously, as a new attorney to Central Oregon, I'm hoping that we can definitely put you on our list for people to refer to in the event they have questions.
Sure. And if you go to the last slide, I've got I've got every phone number that I have connected to me, including myself. So I'm getting a little better at that. So look forward to staying in contact with you guys.
Awesome. And what I'm going to do, guys, for everybody who attended today, I'll get the full list from GoToMeeting, and then I will send everyone else a continuing education credit for this, because this is really good stuff, and I know we can utilize this in our work with our clients.
Great, sounds good. It was a pleasure meeting you guys all virtually, and hopefully get to see you all in person, hopefully this summer.
Thank you so much, Kelly. Thank you, guys.
Bye.